Good evening, everyone. It's 5 o'clock sharp, and I think we can start our session. My name is Skalk de Jager. I'm from the Development Management Department in the City of Cape Town. I am joined by my colleagues Jaco van der Westhuizen, Gregory Joubert, Unati Nobekada, and Vanessa Anderson tonight. And thanks for availing yourselves for this information training session. And I hope everybody will find it useful. Just a few things. Gregory Joubert will, from our side, run the presentation. Myself and some others might then add into those slides as we go forward. After every few slides, we will stop then for a few questions, particularly on those things that we've touched on. So if I can please ask that everybody, please raise your hand or pose it in the IM, your specific question or comment, and then we can deal from it from that point. Before Greg starts the presentation, I think he will probably duplicate a few things right now, what I'm about to say. But I'm sure everybody is aware of the City of Cape Town Municipal Planning Amendment By-law, which was recently approved by the City of Cape Town Council. That was so on the 26th of June July, I can't remember now, this year, and then it was subsequently promulgated in the Western Cape Gazette on the 8th of August. We will touch now on those transitional provisions and the respective effective dates of those specific parts of the bylaw. And Greg will touch on that as we move forward. I'm not gonna hold up it any longer. So Greg, if you can maybe start, and then we'll add in as we go on, and then we'll pause for those specific questions after every few slides. Thanks, Greg. If you can please proceed.
Thank you, Skalk. Good evening, everyone. As Skalk introduced, I'm Gregory Joubert, also from the Development Management Department, within the land use section. So we'll be taking you through the amendment bylaw and touching on all the aspects that have been introduced into the bylaw that may have relevance to yourselves. So just some of this as per the agenda. Thanks, Unati. Just a note that the session is being recorded. And just some housekeeping, please make sure your mic is muted so that it doesn't interrupt the presentation, and that we can just take questions. We'll have sections, as Skalk said, where there'll be questions and the slide will come up, then we can ask questions at that time. As per the agenda for the meeting this evening, the summary of the topics covered. We'll be looking at the background, as Skalk has touched on, some of the key dates, the transitional provisions, the objectives of the amendments as a whole, some of the definitions that have been updated, the zoning changes. So we'll go through each zone as per the DMS and the changes within each zone. We'll look at the changes within the general provisions, parking provisions, the newly incorporated incentive overlay zone, as well as our enforcement enhancements and the affordable rental flats. The affordable rental flats will come in when we speak to the development rule changes within residential 1.
Greg, apologies for interrupting there, but maybe so that's our formal agenda. But of course, please feel free if there's something that we haven't touched on at the end, you are absolutely welcome to also ask and pose those questions at that time. It is on the slide right now, and Greg will touch on it. The purpose of this tonight's session is to highlight and explain some of the amendments, and not necessarily to debate it itself. Of course, that process has passed. So we are here to share and explain basically what the amendments entail themselves. Thanks, Greg.
Yes, this is an overview and introduction to all the amendments. As we said, we're going to be welcoming questions, and then as Skalk has said, it's not to debate the amendments, but just to give you a heads up of what has been included. So just the background, Skalk did touch on it. When the bylaw was introduced in 2015 and adopted, there was a section 27 within the bylaw which stated that the DMS needed to be reviewed every 5 years. So that process started, as shown in the important dates, in 2021. The initial public participation went out for requests for DMS amendments and what changes would like to be seen. The draft amended bylaw was then published, or public participated, in July of 2024, and then the council adoption was in June 2025. From that adoption and from the Provincial Gazette, the effective dates were shown as on the screen. The 8th of August, the section 116 came into effect of the MPT members. On the 1st of September, the affordable rental flats component of the amended bylaw came into effect. So that is in effect as we speak. And then the rest of the municipal planning bylaw amendments will come into effect on the 1st of October 2025.
Greg, if you can maybe just quickly go to the previous screen. I just want to, for those who might not be familiar, I just want to briefly, just 1 minute, talk on the history of the planning bylaw itself, of course. As many of you will be aware, of course, it was introduced in the city of, became effective in the city of Cape Town on the 1st of July 2015. Up till this amendment that we are dealing with tonight, there were 5 ad hoc amendments done. And those were 2016, 17, 19, and then 22, respectively. And then, of course, now this one. Greg did mention that this amendment that has now been completed is as a result of that section 27 in the planning bylaw itself. I just want to quickly highlight again, this was different to the 5 previous ad hoc amendments in the sense, as Greg alluded to, that there was basically 2 rounds. So it was basically firstly an opportunity for everyone to raise ideas and provide suggestions. Council then recommended a directive report for which ones to proceed with. And then the second phase was the public participation on an actual draft itself. So yeah, just a quick brief background to where it came from for those who might not be familiar with that. Thanks, Greg.
Thanks, Cock. So in terms of the transitional provisions within the Municipal Planning Bylaw Amendment, the transitional arrangement for land use applications as per section 142 of the Amendment Bylaw, and that will apply going forward. And then with regards to building plans, the building plan must comply with the National Building Regulations and building standards and other applicable law on the date of the submission of the building plan application. So the date of payment of the building plan is the date that is considered the date of submission, and the law applicable at the date on the date of the payment is the law that will be applicable for the run of the building plan application. Following on from this, there's a few iterations of how that can proceed. So a building plan application submitted before the amendment of the Municipal Planning Bylaw, so which will come into the full effect on the 1st of October, must comply with that pre-amendment provision of the Municipal Planning Bylaw, even if the building plan application is decided when the amendment of the municipal planning comes into effect. So what that basically means, if you submitted before the 1st of October, the legislation, so the bylaw applicable at that time, so the current bylaw will be in effect on that building plan. Even if it's decided after the 1st of October, the legislation or the law, the bylaw applicable when paid will apply for the run of that bylaw. Point 2, a building plan application submitted after the bylaw is amended must comply with the Municipal Planning Bylaw as amended. So if you submit and pay for a building plan on the 2nd of October or on the 1st of October, 2nd of October going forward, the new amended bylaw, as we will be discussing today, will be affecting that building plan. And then a development granted planning approval, so a land use application that's been given approval under the pre-amendment provisions of the bylaw may need additional planning approval if amendment introduces new or more restrictive requirements than the building plan application is submitted after the amendment commences. In such cases, it advised that such application also be tied to a plan similar to lock in the current rules, which may be not be subject to the land use application. So in other words, if a land use application is decided prior to the 1st of October and you submit a building plan after the 1st of October, it's recommended, and we've spoken to our internal staff as well, that the land use application gets tied to a builder or a specific plan, which all the development parameters are shown on, and therefore once the building plan is submitted after the 1st of October, you can still have your tied to plan and your rights of your land use application tied to a plan. A good example of this, as we will speak to later, one of the development rules which has changed, for a simple example, is our residential one height. That has gone from 11 meters down to 10 meters. So a good example is if you have a land use application currently and it gets approved before the 1st of October with a height of 11 meters, and we tie it to a plan showing 11 meters, you will not need a departure when your building plan is submitted, because the new development rules after the 1st of October will go from 11 meters down to 10 meters. But because you've tied it to a land use plan, you won't need a departure for that 11 meters, because you've tied it to a plan, and all the development rules are tied to that plan will then apply to going forward with the building plan. So moving on just to the objectives of the amendments. So in total, or in an overarching look at the amendments, the objectives include alignment with applicable approved city policies, strategies which have changed over the 5-year time, as well as since the last amendment. A big change or a big direction that we took with the bylaw amendment with this amendment was avoid duplication of processes. This can be seen, we'll speak to later, things such as events, filming, informal trading, and the like, where there's duplicated municipal processes, which we then just try to remove. Expanding and recognizing economic opportunities that can be seen through the expansion of our TR2 zone. Expansion of renewable energy opportunities. There's been a long list of new land use types that have been included within this bylaw. Improved emergency housing. We've made it very clear that this is now temporary disaster housing provisions. Incorporation of affordable rental flats as a land use category. New incentive overlay zones. The new rectification chapter, and a new empowerment powers for movable and immovable properties, including vehicles for illegal work. So just going through each one of those, just the rationale behind those. So there's general clarification, improvement to certain definitions. The rationale for these were just improving and correcting the intent and consistency of the definitions. The improved emergency housing, or now temporary disaster housing provision. The rationale for this amendment was, in disasters like a major fire or flood, the city is obligated to create temporary housing on land that can be zoned for such purposes. The intention of this amendment was to make sure that it must be temporary in nature. The incorporation of affordable rental flats. This is a recognition of a phenomenon that is currently happening around the city, and now we are trying to control this phenomenon in a manner that can assist the living conditions of the people using it.
Greg, Justin, quickly, just to highlight again, those components are, of course, already effective now. The affordable rental flats from the 1st of September, yeah.
Enabling economic opportunities, as I said, creating and recognizing new definitions, promoting economic development in terms of land use possibilities. One of the big ones was outdoor restaurant seating within our TR2 zone. eliminating duplication of processes, eliminating the need for land use applications in full in instances where the city already has mechanisms in place to regulate these functions. So as I said, filming, events, and informal trading all have their own separate processes and bylaws. There's no need to duplicate it, so we found that removing it from the land use section is an effective way to make it more efficient process for these phenomenons.
Yeah, Greg, if I can maybe just jump in there again. So, as we've said, this is particularly aimed at filming, events, and informal trading. So, for example, in many zonings, you would see now filming, for example, as a primary use. So, as we say now, from a land use point of view, that is primary, that's a primary use, but you must, of course, still comply with all the other relevant city bylaws which might be applicable. In filming's case, there is a filming bylaw which has been recently updated and gazetted, which do provide for public participation to assess impacts, etc. So, as we say, by having it as a land use application as well is counterproductive. So this was a big thing, and as we say there, to create more efficiencies in the system. The same, of course, with events and informal trading. If somebody do have a permit or the like in terms of those bylaws, then they are also fine in terms of the planning bylaw.
Thank you, Scott. There's been a host of amendments to the development rules within the zone, each zone. Those will be discussed. We'll go through each zone and discuss all the development rule changes as well as the use right changes with each zone. And then our incentive overlay zoning. This has been contained within the bylaw previously. However, there's never been any general or specific provisions attached to it. The incentive overlay zone study provided the necessary provisions and associated conditions to activate this section, and we will be going through those provisions and development rules for that later on in the presentation. We've also included an improved and strong enforcement and other provisions available to the city. So these included a new rectification chapter, combines existing regularization provision with a new revocation and amendment provision to provide an internal remedy for irregular decisions. This is a cost-effective and quick alternative to review litigation. And we've also included a new empowerment powers for movable property, including vehicles used for illegal work. Those two will also be spoken about later on in the presentation. Scott?
Yeah, Greg, maybe if I can also just jump in there. We will talk about this a little bit later on again, but just to maybe highlight many of the particular individual topics that we're talking about tonight, there will be individual advisories going into all the actual detail of what that will entail as well, and that will be released in the next coming weeks. So, and this is, for example, there's a lot of practical things that must happen, for example, with impoundments, and all of that will be unfolded in those advisories. So, just a note on that. This is not the only thing. There's some others as well where, as we say, there will be more detail guidance on how to interpret some of those things.
Some further notable amendments. The section 109A, duty to exhaust an internal remedy. So this is just a provision so that all municipal planning bylaw processes are used prior to taking a decision or process to court. So this is just an example, the new rectification clauses, just so that we can deal with an application or a process within the bylaw means prior to heading to court. The section 111, sub 7 and to 11, this speaks to the method and date of notification, and this is just clarifying our email notification for going forward. So currently we have used email as a method of communication We are now strengthening that with these amendments so that we can now have the clarification within the bylaw. So it now speaks to which email the city must use to notify someone, the responsibility of the citizen to inform the city when changing an email, and then also having a provision of if a wrong email is captured on our system, that the citizen or the public that does not update that email consents to not having or getting a notification due to the incorrect email address.
Greg, yeah, just to add to that. So, of course, emails is not a new thing. It has been now being used by the city for at least the last year or so. But that was a prescription done, and now it's formally contained in the actual law itself. What we are saying here is this is now formally then the primary method. And what we're also saying is that database that the city use in general. So all of the departments in the city draw from the same database. So everybody that in any case do get the bills, for example, by email, we will be using that same email address. I think, and you might get some questions, I suppose, on this as well. People asking, must they re-register basically their email addresses? And the answer is no, we will use what's on the system, unless, as Greg has pointed out, some email address change, and then you must just notify us of that change. But yeah, this is definitely a move forward, I suppose, to use email. As we know, the post office notifications doesn't really happen. Greg, I just want to quickly talk on the earlier point on that slide on rectification. As we've said on the earlier slide, there will be more detailed explanations in the upcoming advisories. But just quickly on rectification itself, I think this is also a new thing. And of course, many people have seen this as a second bite at the cherry, and which is not, of course. A rectification is there to rectify real mistakes happening in a process with the consent of everyone involved. And as we've mentioned, it's a much more cost-effective method of involving high court litigation, etc., to move that forward. But yeah, as we've said, more detail will follow in an individual advisory on that.
Thanks, Scott.
Maybe. But yeah, Greg, if you can maybe please proceed.
Thanks. So just looking at our new and updated definitions. So just firstly off, these are not all the different, we're not going through every single definition that's been updated and minor tweaks, but these are just standout definitions that have been completely included and brought into the bylaw. So that could be of use to yourselves or just for information purposes. So we're not going through all the minor amendments in the definitions, but just the big definitions that have been included. So in Schedule 1 of the bylaw, we've included 3 new definitions: approval, condition of approval, and relaxation. A big one being relaxation means to make a development rule or restrictive condition less strict, which may result in the extension of the development rule or restrictive condition. Obviously previously not defined, and now is a definition within the bylaw. Scott, is there anything you want to add to that?
Yeah, again, maybe just to confirm, there's many other changes. This is, of course, when we say Schedule 1 bylaw, those 3 definitions on the screen, you might be aware that there's, of course, 2 sets of definitions in the bylaw. Firstly, at the beginning, and then before the development management schemes start as well. So those on the screen is relating to the first set. As Greg has mentioned, now relaxation, this is quite an interesting one, is now defined. You might also be aware that previously the city's advice was whenever a title deed, for example, allowed a condition to be relaxed, the city's position was on advice that if that relaxation results in that condition not to exist anymore. Let's take another simple example. Say, for example, there was a building line relaxation from 3 meters to 0 meters. Then the city's position was that that could not be done through the relaxation process because the interpretation was that relax means that it must still exist afterwards in some way or form. But now there is this particular definition which clearly states that a relaxation may result in that rule not being there anymore in effect. So one can then, of course, now use the relaxation option as of the application types whenever the title deed allows that for that, basically. Yeah. Yeah. No, that's all. Thanks, Greg.
Thanks, Cock. So moving from the Schedule 1, we've got new DMS definitions. So we've got affordable, which is a new definition in relation to affordable rental flat and affordable rental unit, and is determined with reference to a policy that is to be adopted by council. The policy has not been adopted at this point in time, but is in draft stage. That will come in soon. We have changed our definition of a boundary wall with a few amendments. We've included event within the definition as per the removal of the duplication of process and making events more of a primary right. We now refer to the events bylaw. There's been changes to our existing ground level. The full definition has been moved from definitions to a provision that will be spoken about shortly. And then we included face of a building definitions. The further definitions, ground level map, we've just added the data set. So from LiDAR information available to the city, we've included where that data has come from. A new definition of kitchenette has come in, and then a few use types: livestock, auction house, outside, outdoor restaurant, dining area, and a big one of roof, which means the uppermost part of a building, which covers the top of a building, and without which the building would be open to the elements. Again, there's two subsections to this, which generally comprises a system of structural members or materials designed to support the roof, and may include a trafficable area on which structures, devices, and equipment may be placed.
Roof never has been defined in the DMS, but now there is a definition for this. Some of you might be aware of the Epstein judgment a few years ago, where it was ruled that a roof may not be used for any trafficable purposes. The inclusion of a definition for this does allow for this now. So the judgment is then not in effect anymore for that particular aspect. Greg will touch on it later on, but all of this must also be read in context. There's a new measurement to height of a building. So we'll touch on it later, but anything that you may put on a roof then as part of that trafficable area, all of those things must, of course, then be within your height limitation. I just want to quickly, a kitchenette is also an interesting one, and we've had a few questions on that already. So kitchenette is now defined in the DMS, of course. Previously it wasn't. So you were allowed to have one kitchen per dwelling. By having a definition for kitchenette now, and it's self-explanatory on the screen there what it is, it opens the door to have more than your main kitchen in terms of smaller cooking areas, in the entertainment area, for example, as a result. But yeah, just some brief comments on that, but we'll take comments or questions on that later on as well. Thanks, Greg.
Thanks, Gok. So just some changes to our definition of terrace, again, with roof now coming into play. We've now created or removed over a portion of a building, and that has a habitable function has been included. We've included top of building, as Skulk said, is the new measurement or way to measure height is now to top of building, and that will be explained when we get to the zoning changes. And then we've also included the definition for a window. Some new, okay, yeah. Cool.
Sorry, Greg. Just to expand a little bit on the top of building definition now. Yeah, as you may be aware, a wall plate has been deleted with the amendment bylaw. So previously in some zonings, particularly for example the residential zonings, you had two height measurements from your EJL. One was from EJL to wall plate and the other one to top of roof. This has now been, as we say, deleted. There is now only one height measurement across all zonings, and that's from the EGL to top of building. But yeah, just a note on that, and we'll speak a little bit later on that as well.
Just to so the new definitions, but these specifically relate to our new defined use types. So affordable rental flats, affordable rental units. This has been spoken about quite a bit. Those are now defined: an auction house, chancery, commune, data center, and then some of our renewable energy inclusions include electric vehicle charging stations, ground-mounted energy systems, micro wind turbines, and then small-scale animal centers, small-scale wind turbines, structure-mounted energy systems, and then supplementary dwelling unit. So supplementary dwelling unit is just a revision of our domestic staff quarters. Domestic staff quarters being replaced with the supplementary dwelling unit, and then our utility scale energy structures.
Yeah.
So,
yeah, I just want to please confirm to everybody again, just to make sure everyone is on the same page. A supplementary dwelling unit is not a fourth dwelling unit in the residential zonings, as an example, and there might have been some confusion on that as well. As Greg has highlighted, it's still it is the previous domestic staff quarters definition, which has now been replaced with this one, and all the requirements to that is still the same as the domestic staff quarters. So yeah, just to confirm, it's not an extra dwelling unit. It's just basically a new word and some new provisions relating to that.
Thank you, Skalk. And then, as we spoke about earlier, removing existing ground level as a definition and is now a provision within item 3B or section 3B. So yeah, I think we're going to move into the zoning changes, and this is where we will discuss all the additional use rights, etc. And yeah, Roland, just a heads up, it's, as we will speak about now, it's no longer SR1 from the 1st of October, it'll be called R1. So just a note there. So yes, we're moving into the zoning changes. Our first one being residential zone 1, conventional housing. The big change to this is obviously a name change, no longer single residential 1 or single residential zoning, but now referred to as residential zoning 1. This has come obviously with the changes over the years with including second dwellings and third dwellings. It was questioned, why is it referring to single residential? So we've removed the single and it's now residential zoning 1. And with that, you can see the table showing all the uses that have been added to the zone. This will be the format for all the zoning. So this is just a quick brief overview of the primary additions, primary use additions, additional use right additions, and consent use additions. You'll see in residential zoning 1, affordable rental flat has been included. Your supplementary dwelling unit under additional use right, and a big one is place of instruction. So place of instruction being an ECD for 34 kids and less is a additional use right. So again, additional use rights are a use right that you can take up if you comply with conditions. We'll get to the conditions shortly. And then on your consent use side, you'll see our sustainable energy uses have been included. As per most of the zones, the sustainable, so ground-mounted energy, small-scale wind turbines, etc., have been included as a consent use.
Greg, just a quick note, and that as Greg has mentioned now, we will be just showing what uses has been added as an example to zonings. But just please note, yeah, of course, as we've mentioned at the start, so there's been many definition and tweaks and amendments. So if you, for example, see a use added here, just make sure to also follow up on those current uses which may be allowed in a zoning, because there might have been some some sub-uses added to that particular current use as well. So yeah, this is just where a particular use on its own, as defined, has now been added. It's not necessarily particular to residential zoning 1, but I'm thinking, for example, where a business premises is a primary use. A further example there is we won't necessarily show business premises on the slide, but if you go and look at the definition of business premises, there's some further tweaks added to that particular definition as well. But yeah, just a note on that. Thanks, Greg.
Thanks. Moving on from the uses, we're looking at the development rules for residential zoning 1. As we've spoken about earlier, a big change to all of our or mainly to our residential zones. There's no longer a wall plate within the DMS, so therefore it is a one height for determining the maximum height above existing ground level, and that is to the top of a building. So there's no more top of roof or to wall plate, where it was used to be 11 meters to top of roof, or to top of roof, and then 9 meters to wall plate. It is now a single unit or a single measurement, and that's to top of building. As you can see, all the changes in red is what has been amended. So you can see all of the heights have been amended to include one single height limit, with coverage being included in a few of the zone or land unit areas. We've also gone from in our 350 squares to 650 square meter property sizes. We have taken it from 3 meters after the 60% down to 1.5.
Greg, yeah, just with the further note there, then for that particular use size category, there's now the addition of a coverage requirement.
Correct.
So it's a reduction from 3 to 1.5 for that, as you've mentioned, the past the 12 meters, but then of course you must take into account the 70% coverage issue.
A notable mention within the development management scheme under residential 1 is item 22C3 or III. Notwithstanding subparagraph 2 within the first 12 meters along a common boundary measured perpendicular from the street, so there's been a deletion, and where a building is not set back from such common boundary, the height is determined in accordance with the table. Previously, if you set back your structure within the first 12 meters, you had to comply with the 4-meter height restriction around your 3-meter buffer, pretty much around your property. The change now says if you set back within the first 12 meters, you can still use your full height. So as shown in the diagram, within the first 12, this structure is set back half a meter. You can still use your full 10-meter height. You no longer need to comply with the 4-meter height restriction.
Yeah, this is of course only for that first 12 meters. Beyond the first 12, you'll still have to comply with that further height requirement. But as Greg has explained now, so previously, when your building was on the boundary, you could go the full height. When it was set back in that 3-meter zone almost from the common boundary, then you had to drop to 4 meters for that particular 3 meters, and then you can go to your full height after that again. So this is now just simplifying that rule, so that if your building is set back a little bit, you can still use the full height. Just please keep in mind, of course, any further requirements that may be applicable, such as the window and door placements and those kinds of things as well.
Thanks, Kalk. Just a note on the new additional use rights within residential 1. 25C, it speaks to your supplementary dwelling unit. This is, as we said, the previously mentioned domestic staff quarters. This is just a very brief overview, but this within the condition speaks to a limited size and that you can only have one. 25D speaks to our affordable rental flats additional use right. So this speaks to that can only be within the areas permitted as per the map. You can only have it where there's no second, third, or supplementary dwelling unit. So that refers to the questions that have been asked earlier. If you have your main dwelling unit, a second dwelling unit, can you still have the affordable rental flats? No. The conditions also speak to you having 8 affordable rental units with the main dwelling house, or 12 units when there's no dwelling house. It speaks to the maximum floor area of 160 squares where 8 units are permitted, or 240 when you have 12. And these are all subject to certification that development contributions have been paid. We will go through these a bit more in detail, and we will show you the map. 25E speaks to the small scale wind turbines. It just speaks to the conditions speak to the maximum size, buffer area, and decommissioning of the wind turbine when no longer needed. And 25F speaks to the place of instruction, speaks to you can have it when it's 34 kids and below. It speaks to hours of operation, etc. And a big one is that notice of no objection must be still signed when taking up this additional use right. So if that additional use right wants to be taken up, no objection letters will be given to the owner who wants to take up that additional use right, and he or she needs to go to the surrounding neighbors with the no objection letter stating that they wish to take up this additional use right, and that the neighbors don't object to it. If the neighbors object to it, they cannot take that additional use right up, and will need to submit a formal land use application.
Yeah, Greg, maybe just to elaborate a little bit further on that one. Just quickly now on the notice of no objection, that's of course a determination that must be made by the city who is potentially affected persons. So there will be, as with other similar types of applications in the past where notices of no objection might be applicable, the city will identify those properties that the city believe will be affected, and then the owner needs to get those no objection letters from those particular owners. If they can't do that, as Greg has mentioned, then of course the additional use right falls away. There was a IM question, I think, John. Additional use rights are still subject to the main use of a dwelling and undertaken by the occupant of the property, meaning ECT is only permitted if used as a dwelling as well. So yeah, there is these further additional use right conditions. For example, the place of instruction one is item 25F, and there's particular conditions there. But all of this must be read with the general additional use rights conditions as well under 21, item 21, where we do say, for example, that it must be a residential, mainly a residential. There's who might be the operator there, and then the employees, which might the number of employees, etc., etc. So in short, yeah, just to answer your question, it must be read with the general additional use right conditions as well.
So yeah, just coming back to the presentation, just specifically with regards to affordable rental flats, as we've said that it's been included now in residential zone 1, residential zone 2, and local business zoning 1. The affordable rental flats is an additional use rights, as we've said, and the owner of the land may exercise it without a land use application, but has to be compliant with the conditions as we've going to be going through now. So subject to the compliance with the conditions listed under 25D, together with the applicable development rules. And then lastly is provided that the property is located with the area of the map approved by the city. So we'll also show you that. So the conditions under 25D, that the affordable rental flats may only be developed and permitted on a property where a second dwelling, third dwelling, or supplementary dwelling unit has not been developed. So this has been a question that's been come up quite a few times. You can have your affordable rental flat where there isn't a second dwelling, third dwelling, or supplementary dwelling unit. An affordable rental flat is only permitted as an additional use right on properties within the map. We'll show you where you can get the map, and we'll show you which layers need to be turned on. The number of affordable rental units, as we said, is 8 units when there's a dwelling house on the property, or 12 units when there's no dwelling that exists on the property. Or where the floor area of 160 squares, or where with a maximum of 8 units, or 240 for 12 units. And then the height of the affordable rental flat cannot be more than 8 meters, and the construction of the affordable rental flat is subject to certification by the relevant municipal services department that the relevant charge has been paid.
Yeah, Greg, maybe if I can just quickly talk on that last point there. Of course, as with many things, when there's a change in use and increased use, a development charge is possibly applicable. And this is just for info, but I believe the policy has been, not the policy, the calculator, the development charge calculator has been updated with a new charge as well for affordable rental flats particularly. I don't have the exact details of what that amounts is, but yeah, you're free to speak to the relevant engineers whenever you might get to that point. Yes.
Thanks, Scott. And then just so this is our online map viewer. So this is on the City of Cape Town website. We can provide a link in the IM of the web page, and you can see under the spatial planning layer, under the planning layer, we've got affordable rental flat areas, and that will show you, obviously, if you zoom in on the map, you'll be able to see the mapped areas. Moving on to our residential 2 zoning. So this is obviously previously named single residential 2. It's now the name is changed to residential zoning 2. And this has been a name change. And then again, just your changes to your primary, additional, and consent uses. Again, affordable rental flats, supplementary dwelling unit as additional use right. And then the consent uses being informal trading, small scale animal center, chancery, flat, and ground mounted energy systems. Changes to the development rules, the floor factor has increased, and then the maximum height, again, all of the height changes have been put in red. It's because all of the height changes are now to top of building, and this is 9 for dwelling units and 10 meters for other buildings. 20, we've got a question regarding 25AD. Is a second or third dwelling required to be one building? 25AC has been deleted. Sorry, let me just go back to that. You're saying 25A. Give me a second. Is this the conditions regarding the second dwelling? So questions regarding 25AD. Second dwelling contained within the same building as the main dwelling house must be designed. So that condition has not changed. C has been deleted.
Yeah, James. So I think C has been deleted. You're correct, and that's to do with height requirements. So any second dwelling will, of course, then be only subject to the base zoning requirements in terms of height. And that was when it was a separate structure to the main dwelling. D is still there, and D is just saying whenever it is contained within the same building as the main dwelling, then it must, of course, be designed to look as one. You'll also note that B has also been deleted, and that's to do with the architectural style, where that previously that was a formal requirement, but all of that in future can and will be dealt with by the building plan stage.
Sorry, excuse me. The question is, does a second dwelling have to be, can it be a separate building? Because some plots are very long.
Yes, of course. Okay. Yes, it can still be a separate building.
Thank you.
So it just says now C, as we say, has been deleted, but that was just stating whenever it's a separate building, there's a certain height requirement. So by that deletion, it doesn't mean it cannot be separate anymore. So it can be, yes.
Thank you.
Then just Unati has answered the question, can a second dwelling be converted to affordable rental units? Yes. What you will then have to just remove the second dwelling will show the removal of the second dwelling in the plan, or the conversion of the second dwelling into either 1 or 2, or however many affordable rental units with the main dwelling, so maximum of 8. Moving on to general residential 1, our group housing. That's just the uses that have been added. Again, our sustainable energy systems, supplementary dwelling unit also being included in additional use rights, and then consents including guest house and chancery. Again, just our change to top of building is now 9 meters. The rest are all the same. Our general residential 2 to 6 zone, again, third dwelling coming in as a primary right with our energy systems, home occupation coming as an additional use right, and then consents have now included restaurant, guest house, and then our ground-mounted energy systems. There have been no changes to the development rules within GR 2 to 6. In community zones, community zone 1, we have added our shop to a consent use, with our energy systems coming in as primary as well as consent uses. The changes have been a change to coverage. Street and common boundaries have been reduced from 5 to 3. In our regional community zones, we have included business premises as a consent use. As Skalk has earlier pointed out, there have been minor tweaks to business premises, so that could be a broader definition just to be looked into. But our energy systems being across the board, so wind turbines, small-scale wind turbines, and utility-scale energy structures being in the various primary, additional use, consent use uses. Again, changes to coverage and street boundary being reduced to 3 meters. So, Russell, I see what's the difference between small-scale turbine and micro turbine. We can look at the definitions. Just let us get through the zones, and then we can come back to the definition of those. In terms of local business, the uses that have been added, obviously filming being a big one within the primary use right, affordable rental flats coming in local business 1, and then small scale wind turbines on properties that are greater than 650. Restaurants being added to local business 1, and then our small scale animal centers also being added. One thing to just note within local business 1 zone is that house shops conditions have been removed, and then item 52 applies within this zone. The only change within the development rules within local business is the change of height, as shown on the screen. Local business zone 2, filming again becoming a primary right, and no changes to our development rules within local business 2. General business zone, general business 1 to 7, chancery being added as a primary right, and our energy systems being across the board. Our changes to our general business zone, GB 1 to 6, only changes being into our heights, and that's to align with stories within the, I think that's been an increase just to align with the number of stories and to align with the sizes of each story. A mixed use zone, again, our sustainable energy solutions across the board, and small scale animal centers being included as a consent use. The only change to our development rules within the MU in mixed use zone 1 to 3 is just to the top of building height change. A general industrial zone, the energy systems across the board, just being the inclusions to the uses, and the inclusion of the increase in height with regards to the height restriction to the top of building, and the common boundaries obviously being reduced to 0. Risk industry, just again, our energy systems being across the board, and no changes to the development rules within risk industry. Utility zone, the same thing. Our filming has been added as well within as a primary right, and urban agriculture as a consent use. And within this zone, which has been done in the previous zoning scheme, is that the development rules are controlled by an SDP, so there's no changes to any development rules within this zone. Transport Zone 1, filming has been included as a primary right. As we've said previously, filming being a duplicate process, so that's been added as a primary right. And then our energy systems across the board, no changes to any development rules within Transport Zoning 1. Transport Zoning 2, our public road and public parking, filming being a primary right, and consent uses. A big change that's come into Transport Zone 2 is that consent uses are any other uses defined in this development management scheme. So any use that's defined within the development management scheme can be applied for as a consent use within Transport Zone 2. And this is controlled by an SDP, so there's no development rule changes. Transport Zone 3, our toll road zoning. This, just to be noted, is not a zone currently in the city of Cape Town, but the uses still have been added as filming and our energy systems, again controlled by a SDP. So no changes to any development rules because there aren't any. Our open space zoning, environmental conservation. The filming has been added as a primary right, with our energy systems being added as a consent use. And this again is also controlled by an SDP, so no development rule changes. Open space 2, our public open space, same thing. Filming has been included as a primary right, with our energy systems being a consent use, and the same is controlled by an SDP, and there's no development rule changes. Exactly the same for open space 3, filming as a primary right, and our energy systems as a consent use, also controlled by an SDP. Agricultural zoning, there've been quite a list included as consent uses, obviously with the energy systems across the board. Supplementary dwelling unit being an additional use right, and then including the auction house, livestock auction house, place of instruction, and a veterinary practice as a consent use. New additional categories for building lines have been based on property size have been included for the development rules within agriculture. So as you can see, property, previously it was only 20 hectares, then you had a 30-meter building line, but there are smaller properties within the city of Cape Town that are zoned agricultural. So there have been categories that have been added per property size, and then you'll have a corresponding building line. So 10 hectares to 20 hectares, you'll have 15-meter street building line. 2 hectares to 10 hectares, you'll have a 6-meter building line, and then under 2 hectares, the residential 1 applicable category will apply. In our rural zone, similar to our agricultural zone, there have been a list of additions to the consent uses. One of the notable ones is a recycling center has been added as a consent use. And the only change is to the development rules is to the top of building. On to our general provisions in the bylaw. The changes that have been made here. Just to item 121, encroachment of building lines, there's been a few additions. So 121A1A, walls, fences, and gates and other being used for architectural features, that is now under the general provisions of the encroachment of the building line is permitted. It's an exclusion. Outdoor briars, pizza ovens, provided that the chimney and flue shall be not closer than 1.5. That is also now an exclusion from the complying with the building lines. Air conditioner units, heat pumps, or similar systems have also been included in 121A. Then 121A, common boundary building lines for unscreened trafficable roof, balconies, and terraces. This is a new addition. With the addition of the trafficable areas permitted on a roof, a new general provision has been included to try and minimize impact on privacy. So 121A relates to these trafficable roof areas or terraces or balconies, etc., or decks that are used for entertainment purposes or just trafficable areas. So an unscreened trafficable part of a roof, balcony, or terrace facing onto a common boundary must be set back from a common boundary building line or at least 2 meters from the common boundary, whichever is more restrictive. So this is to try and address the privacy impact of these trafficable areas. And this is something that can now be enforced on these trafficable areas. Just moving on to item 130 under our general provisions, additions of minor freestanding base stations. That's been included. So 134, a minor freestanding base telecommunication station may be attached to a street lamp, traffic light, road directional sign, a camera, flagpole, etc., or similar support structures. And then 135 just goes to the dimensions and limits on those that sort of minor freestanding base station. So this is under our telecommunication general provision. 133A, so structure mounted energy systems. So as we've seen, these energy systems have been applied in most of our zones. And so the general provisions accord to that will be applied to these is that it'll just be controlled by a SDP. So large scale solar farms, etc., these will all be controlled by SDPs. It's just one of the general provisions. 136B, so changes to our boundary wall general provision. Security devices on walls have been added, so such as electric fences and barbed wiring, that's been added in the general provisions. A maximum height from a street boundary has increased to 2.1 meters. This is to align with the prefabricated structures such as clear view fencing, etc. Previously it was 1.8, has now been increased to 2.1 to align with these prefabricated structures, as well as visually permeable garage doors and gates have been added to the calculation. So previously your garage doors, sliding gates, pedestrian gates, etc. were excluded from the permeability calculation for boundary walls. They have now been included. So you must include the sliding gates, garage doors, etc. into your calculation for permeability. Our parking provisions, I do see we've got quite a few parking questions. So just what's shown in red is the changes to the parking provisions. All the rest are still the same. These are the only changes. One of the big changes being that we had a main dwelling for single residential and a main dwelling for residential 1 and a main dwelling for residential 2. Those are the only parking provisions supplied for main dwelling. We have now changed that to say main dwelling house across the board for all zones, and then any other zoning than R2. So now the main dwelling parking provision is across all zones. Previously it was only for R1 and R2. Third dwellings have been included. We've included social housing and affordable housing. Just a note that is not applicable to our affordable rental flats. That is a separate parking provision. And as is been shown in the IM by Onati, the parking provision for affordable rental flats at this time there is no parking provision. We are in conversations with our Transport Department, and that will be coming out when we make the determination. And then the last one is any retail use. Part of a warehouse now has a parking provision. So Cindy, just to answer your question again, is there additional parking requirements relating to the proposed affordable rental flats? No, there are no parking provisions at this time for affordable rental flats and affordable rental units. The social housing and affordable housing does not apply to affordable rental units. This is just, again, a high-level overview of the incentive overlay zone and what it's introducing, etc. So item 155 and 165 are the items relating to the new incentive overlay zoning. So the 155A speaks to a land unit within a zoning, and it speaks to the different zoning categories that can be used within the incentive overlay zone, as well as there needs to be those zonings within the areas depicted on a plan. These plans have been advertised and the people affected have been notified. So there's 5 different areas that have been identified as incentive overlay zoning recipients. 1 in Athlone, 1 in Belleville, 1 in Maitland, 1 in Parow, and 1 in Deep River. And these areas, if you have within the zones shown in A, and you're within the plan depicting that you're within the incentive overlay zone, then the incentive applies to you. Again, these maps are on our city map viewer, or on the viewer, same as the affordable rental flats layer, and they can be seen there. So 156B then speaks to the use of the property. So if you are within the incentive overlay area and you have the different zone, the different zoning then has a corresponding increase or incentive. So different uses for each zone. So residential zoning, your increase in incentive is that you can now have a house shop, guest house, bed and breakfast, and then consent uses are place of assembly and hotel. So it's an incentive to be in that area, and it's an increased use right. Same with the general residential and local business. You can just see that the use rights have increased in intensity and scale for those uses or for those zones. 156C then speaks to the development rules for each of the zones. So again, the development rules, if you're identified or within this incentive overlay zone, you have an increased development rules or more relaxed development rules, so you can use your property to a greater extent. You can see just in the residential 1 zoning, the coverage has increased to 100%. Your maximum height has increased to 12%. Your street building line has gone down to 2 meters, etc. So the development rules have given you an incentive to be in that incentive area. So just our last section that we're just going to be giving a touch on is our enforcement enhancements. So we have spoken about it previously in the beginning of the presentation, in that the rectification or revocation as well as impoundment provisions have been included. So just a high-level overview of what these look like. So our section 122A to 122M speaks to rectification, and the objective of this is to promote efficient law enforcement, lawful development, and efficient administration by empowering the city without the need for judicial review. This is to revoke or amend approved building plan, to approve a replacement building plan, and to regularize a contravention. So the outline of these within this section is looking at the revocation of an approved building plan, approval or approved building plan, the amendment of an approved building plan, the amendment of an approval, who can initiate the revocation or amendment, and the procedure for the revocation. So as we said earlier, this is something that has to follow a full procedure, and this is outlined in section 122. This is something that will be getting further advisories, and these advisories will obviously be posted on our plan and build it right, and will be posted to the industry. but further details will come through advisories. So then I don't see any further questions or any hands. So just moving on to impoundment. So this is another one of our enforcement tools that we've included or introduced into the Municipal Planning By-law. Then the objective of this is just to impound movable property, which is being used or likely to be used on land units that is contravening the bylaw and the National Building Act or an order that's been given. So again, this is something that is very procedurally based. The full procedure of this is outlined in section 135A to 135G, and the outline speaks to the notice for the intention to impound, how we need to serve a notice, the decision to impound, and a warrant for the impoundment, as well as the execution of the impoundment and the return or disposal of the impounded property. This process will be in conjunction with our law enforcement. It won't be just our department that runs this process, but as we said, this is a very strict process-based procedure, and it's not something that we can just rock up at a door. But yeah, it's just it is a full process base which gets courts involved, etc. And as we've said, further details will be provided through advisories on the section from our legal department. Presentation, as you can see, my email address is there. There's been a few things that we could take offline. Please feel free to copy the email address there, gregory.joubert@capetown.gov.za.